I'm gonna stay back here to be able to move the thing.
Fair enough. For the recording.
For
the recording. Or can you maybe like do one of those? And then I feel bad for people watching the recording and like they're not gonna see anything.
Yeah.
Besides.
True. Well.
We don't have a clicker, right?
No.
Yeah.
And it's
They'll
backwards.
see you. They won't see me.
Maybe we should reverse that. You're
I
better
know.
dressed than me for this. I feel like you should be on the video.
Liz, you should be on the video.
No.
Alright.
I insist.
So do you want to introduce yourself?
Yeah, so I'm Liz. I'm a law clerk at Legal Aid at Work this summer. I'm a second year law student going into my third year, and so I work with Stacy in the Race and Economic Justice Project.
Do you want to go next slide? So we're here to talk to you about your workplace rights, specifically as a job seeker. And next slide. So just to tell you a little bit about Legal Aid at Work, we're a nonprofit based in San Francisco, and we're a civil and workers' rights organization. And here are a few of the things we do. So we provide free services, bless you, to 3,000 people across California each year through our workers' rights clinics and our helplines, where you can call in and talk to a legal counselor or a lawyer and receive one-on-one tailored advice for free about your employment-related issue. We also offer extensive practical legal information about your employment rights and trainings like this one. And online as well, we have over 100 fact sheets related to issues related to work. We also advocate for policies at the local, state, and federal level. So whenever we see that there are areas where workers are missing rights or where there are loopholes in the law, we advocate to change those. And we also enforce civil and employment rights through litigating, so actually filing lawsuits in state and federal court.
And so one of the projects that we host at Legal Aid at Work are these workers' rights clinics. You can't see the phone number super well right now, but we run these workers' rights clinics. They're throughout the state of California and then throughout the Bay. The closest one to here is in East Palo Alto, and that runs during the school year. It's staffed by Stanford students. But at each of these clinics, we take walk-ins or call-ins, and people have an opportunity to talk to a trained legal advocate about their workplace issue. And then we then confer with an attorney to get more information and check that we're giving you good advice. And then we respond back and give you sort of the next steps. Often it's referrals to agencies, but it might be general information about what your rights are, telling you whether a violation has happened, that kind of thing.
And we'll also pass out, we have a stack of postcards with this information, so we'll pass them out so that you have the phone numbers you can call to make an appointment. Okay. And so, very difficult to read, but I want to tell you a little bit more about the Racial Economic Justice Program at Legal Aid at Work, which is the program I'm a part of. And so what we do is we protect and advance the employment rights of low-income people of color who face barriers to employment or problems at work or discrimination because of their race. And so I'm going to start off with a little poll here. And if you feel comfortable, obviously, please raise your hand if you've ever heard of the Fair Chance Act. Have you ever faced discrimination at work or in getting work because of your arrest or conviction history? Do you know what the minimum wage is in Redwood City? Okay. Have you ever been paid less than coworkers of a different race doing the same job? Okay. And have you ever heard others using racial or religious epithets or slurs at work? Okay. So this is going to provide us with a little bit of a roadmap of what we're going to talk about today. So the first thing we're going to talk about is ban the box or fair chance. And so these are a set of laws that most of which are actually new in California and in different localities across the state. They relate to your rights as a job seeker or as a person working with a criminal record. And a lot of these laws we've seen, partly because they're new, we see a lot of employers making mistakes on these. They don't know that these laws exist, and job seekers don't know what their rights are under the laws. And so we'll also pass this flyer out at the end of the presentation, but it's important to know that you have rights as a person with a criminal record, that you're more than just that. Some of them here are listed. Your rights may have been violated if you were asked about your conviction record or arrest history on a job application, if you were asked about your conviction record or arrest history before receiving a job offer, if you were told by a potential employer that they didn't hire anyone with felonies, if you weren't given written notice that a job offer would be revoked, if you were denied a copy of your background check, or if you were not given an opportunity to respond to a notice that your job offer would be revoked. So again, these are the different things we're going to cover more in detail, but basically what you want to remember is there are three things that the Fair Chance Act laws cover. What an employer can ask you about related to your arrest or criminal history, when they can ask you, and then how they can use that information. So those three things are what we're going to cover. What they can and can't ask you, when they can ask you, and how they can use that information.
And so I'll be starting with the what they can ask you. Again, this is kind of hard to see, but I'll say them out loud too. It's okay. I think we kind of messed up the presets, so that might be your fault. But there's certain information that your employer generally can't ask you about unless you're applying for very specific positions. So first, they can't ask you about arrests that didn't result in a conviction. So just because someone got arrested doesn't mean that they have a conviction history, that the arrest ended in anything, and so employers generally can't ask about arrests in general, unless it's an open case. So if it's an open case, there was an arrest and you're say out, you have nothing's happened yet, but it's an open case still, they might be able to ask about that in some situations. They can't ask if you've been in a pretrial or post-trial diversion program. They can't ask about judicially dismissed convictions, nor sealed convictions. They also aren't supposed to ask about juvenile court. So there's a pretty long list of things that they're not really supposed to ask you about. But again, there are some exceptions. So if you're applying for a law enforcement position, for example, some healthcare facility positions, there are certain exceptions to these rules about things they can't ask you about because of, you can imagine their reasoning. They're saying, oh, well, for safety, we have to be able to ask about that. Or so there are all of these carve-outs because of the lobbying of different groups to make sure that there would be carve-outs in the law, that they wouldn't have to follow these rules. So, for better or for worse.
So that's sort of the what, right? So those are things that most employers can't ask you about, period. But there are things, right, that aren't on that list. And so next we're going to talk about when they can ask you about criminal history. So most employers aren't allowed to ask anything about your arrest or conviction history until after they give you a job offer, a conditional job offer. So they have to say, I think you're qualified and I want to hire you before they can run a background check on you, before they can ask you anything about your criminal history. And that's a big change in the law. That's one area where we're seeing a lot of mistakes happening. So these questions, right, are questions we see on job applications. Have you ever been convicted of a criminal offense? Have you ever been convicted of a crime? Have you ever been convicted of a felony? And those questions were common questions on the applications, and they still are. But these questions, for most employers, they're not allowed to ask that. Right? So they can't ask you until after they say, I want to hire you.
Yep, so that brings us to the, oh wait, did we skip one? No, that's it, you got it. So when can they ask you? So we told you what they generally can't ask you, but when can they ask you? Can I show the options without it showing the answer?
Yeah.
So is it before giving an application, on the application, during the interview, or after offering a job? Exactly, after.
So it's D, after offering me a job. That's when they can run a background check. That's when they can ask you about your criminal history. But before that, before they say, I want to hire you, they can't ask. Yeah.
If during an interview you're asked, what do you counsel people on what to say, or do you just, because I think many people would be really pressured before a job offer.
That's a really great question, right? So what happens if you get asked this question during a job interview? Do you have any felonies? Do you have any criminal history? And that is happening. And it's unlawful, but it's happening, right? And so that's the sort of where the rubber meets the road and where the person has to decide for themselves, right? What do they want to try? What are the risks and what are the benefits associated with either, trying to not respond, maybe saying something like, I don't think that you're allowed to ask me that question. There are a new set of laws, called the Fair Chance laws, where you're not supposed to ask that question. but then what does that signal to the employer, right? Is the risk. You could answer it, right? Even though you don't have to. Lawfully, you don't have to answer that question. Lawfully, the employer shouldn't be asking the question. But maybe you want to sort of say it up front and try to explain it before the employer gets the background check. And so it's really, I do talk to people about that, but I don't have sort of one answer fits all. I think it's a really individual choice that each person has to make. But I think it's really important if you are a job seeker with a criminal record to practice that before, right? Try role playing that with a friend, or I've done that too with clients, right? What are you gonna say if they ask you, do you have felonies? What are we gonna say if they ask you, do you have a criminal record? And then have that prepared so that the person knows going into their, I'm gonna do this or I'm gonna do that. But I think, either option are good or bad options depending on what the person wants to try to do. Yeah, great question.
Are educational institutions exempt from this?
Not generally, no. So there are some sort of specific exemptions for folks who are working with children, and there are specific roles that apply for them, but there's no sort of general exemption to these laws.
So they can ask about things like crimes involving children or a history. So, but when they run that check, they can only use that information. They're not allowed to use other information that may come up in the background check. So they have to search for specific crimes. They can't search just generally because they're an educational institution. It has to be job related.
So then after a conditional job offer, right, the person says, I want to hire you subject to a background check, right? Then the employer can ask about criminal history or run a background check only with your written permission. So they have to get your written permission saying that's okay. Sometimes the employers put that on the job application. They say, check this box if you're giving me permission to run a background check if I decide to hire you. But they have to at some point get your written permission. And so we have a little timeline here. I'm not sure if y'all can read that. It says job application. Oop, not yet.
Oh, sorry. I'm jumping again.
So can an employer ask you about your criminal history on the job application? Who thinks yes? Who thinks no? Yeah, great. So no, right? Okay, what about at the interview? Can an employer ask you? Who thinks yes? Who thinks no? Yeah, exactly, right? No. So then we have our job offer, and only then can they run a background check. Only then can they ask you. And they need, do you want to click again? And it should be on your convictions only, because remember, what are they prohibited from considering? Arrests, right? Arrests that are not currently open, they can't ask you about. So they shouldn't be getting that information from the background check. So the background check should only show up your convictions. Does anyone else remember anything else that shouldn't be showing up on the background check?
Juvenile records.
Juvenile records, great, right? Does anyone else remember anything else? So records that have been expunged or dismissed, right? Records that have been sealed. Yeah.
About many years, it's been decades.
Yeah. So we'll talk a little bit about that. There are restrictions on background check companies of how long they can keep showing up conviction records, and if they're older than 7 years, they're not supposed to be showing up. So that's something else to keep in mind. You're sort of getting ahead a little bit, but okay. And then do you want to click again? And so they also, remember, for that background check, they need your written notice to you that they're going to conduct a background check and your permission.
So yeah, this is the one that we jumped ahead to. So when they're running these background checks, they're sort of different. There's different information that the government can get versus what private companies can get. So it's important to keep in mind whether you're applying to one or the other. So private companies, it's a little bit easier. These commercial background checks can't report arrests that didn't lead to convictions. Convictions older than 7 years, so that's our time, with some exceptions. I don't know what the exceptions are. Convictions that have been dismissed or sealed, marijuana convictions older than 2 years, and then diversion or juvenile cases. And so it's a pretty limited set of information that these private companies can gain through a commercial background check. And sometimes they do contain mistakes. And so something that's really important to do is to ask for a copy of the record that your employer runs. So when you find out, if you find out your employer is going to run a background check, always ask for a copy so that you can correct any mistakes that come up on a copy of the background check. So say something, an 8-year-old conviction is on there, something that was dismissed, something is labeled as a felony when actually was a misdemeanor. So it's really important to check these actual documents to make sure that they're correct, because they're not always correct, and there can be a lot of different problems that come up in that process. That same caveat runs for the government one, so always ask for a copy, check to make sure that there aren't mistakes. But these are going to have potentially different information, or they're going to be coming from different companies. So they might have your full conviction history. They don't have that same limitation of 7 years if you're applying for a government job. So just because it's on there doesn't always mean that the employer can use the information. So just because these government background checks have more information on them, it doesn't mean the government can use more information to make an employment decision. It just means that that's what they're getting because it's a different kind of background check.
So for example, I might be applying at a job at a hospital or at a job working with children or seniors, and I might have an expunged conviction or a dismissed conviction, and the person runs a government, a fingerprint, or live scan background check on me, which they're allowed to do. That's all legit. And then it shows up, my expunged conviction shows up on that. Even though they have access to that information on the background check, that employer still can't use that information to deny me a job. So even though they have access to it, they can't say, I'm going to deny you this job, I'm going to take back the job offer that I gave you because of that. And so the distinction here is an important one, but in some ways it's not, right? But just to let you know that they'll have more information about you, but they may not be able to use that information in those jobs.
So is the background check still required to indicate those cases, or do they have the discretion not to include them because they?
So for the live scan one, it usually includes everything, or includes most everything, although there are errors sometimes, right? So, but for the private companies, they're regulated on what they can and can't include. So if they include anything on this list that Liz went over with you, then that's something unlawful that they're doing.
There's a number of people that come in that are applying for various jobs, and they're like, yeah, and this came up, and it's something from '89 or something, and I'm just always shocked of just like, how did they even get this?
Yeah.
So that's something I can tell them is if you do not perform a live scan,
It shouldn't be on there, yeah.
Be on there.
Yeah.
Okay.
And then that's something that you can work with, maybe if we can go to the next slide. So when there are these errors, right, when things that are on there that shouldn't be on there are on there, or things that are just wrong are on there, then you can work with the background check company and the employer at the same time to correct that, or to make sure that the employer knows you're not allowed to use that information against me, right? And so that's why it's really important to go over these really carefully. So they're sometimes really hard to read, and there's a lot of variations because there's, dozens and dozens of background check companies out there. Some are better, some are worse. Some have better records, some have a lot of errors, but common errors that come up are, especially if you've worked with a clean slate program, to have your convictions expunged or dismissed. That's something that's a really common error where it will still show up as active. It won't show up as dismissed. Another common error is convictions that are older than 7 years showing up on the commercial background checks when they shouldn't be there. Another common error is that sometimes it'll say it's a felony when it's really a misdemeanor. So it'll have the wrong characterization on there. And I've even had clients who have had another person's criminal history entirely with a similar name, or there was a typographical error where a number on the Social Security was transposed, and so they have someone else's criminal history put onto their background check.
What if the information is actually incomplete? Like
Yeah.
there's no detail on the page.
Yeah.
It's just, it could be a repeated entry.
Yeah, that's a really great point. So sometimes cases get transferred from different jurisdictions, right? You were in San Mateo and then you got transferred over to Santa Clara. And so the San Mateo one will have no information about the resolution, even though it's the same one as the Santa Clara one, which you then went and got expunged or dismissed, right? And so that's another common error that comes up. There's actually statistics that the Bureau of Justice's database, basically about 68% of their criminal records are actually missing that disposition. So information is totally missing about what happened. So they only know you got arrested, you got charged, and we don't know what happened afterwards. So this is a very big problem, right? And a lot of more and more employers are relying on background checks, and this is part of why these laws were passed, because people were realizing people who shouldn't be denied jobs are getting denied jobs based on bad record keeping, right?
Yeah, so you said even if something shows up on their record, if it's an old case, more than 7 years or expunged, the employer is not allowed to use that. But don't you think employers might have a way to camouflage that that's their reason?
Yeah,
So
yeah.
how would they do it, and how do you argue against it? How do you prove that, no, you're lying? You're
Yeah.
not hiring me because of that conviction,
Yeah.
which was more than 7 years ago. But
Great
So-
question.
how do you
This
deal
is
with it?
another when the rubber meets the road question, right? When the theory of the law meets the reality of what your job seeking is. And so this process that we're going to talk about is designed in some ways to not allow the employer to hide when they're taking away a job from you because of your criminal history, right? So they have to say, we want to hire you, right? So we want you before they're allowed to have access to this information. And so the only thing that changes between when we want to hire you and now we don't want to hire you is that they got access to that information, right? So that's this law's way of trying to address that. What happens if they get access to it beforehand because you decide, for instance, to answer during the job application question, right, that you decide to disclose the information? So then it becomes a little bit trickier, and we have to try to marshal evidence, indirect or direct evidence of, did they say anything? How did they respond to when you told them about your criminal history? Have they hired other people with criminal histories? Then you try to sort of look for more indirect evidence that this was the reason why, but it is a lot harder. But this law is sort of designed to make it so that the employer won't have that information until they affirmatively say, I want to hire you. So then they can't they can't lie and say, oh, actually, I filled the position already. No, you told me you were going to hire me, right? And then you got my criminal history information, and now you don't want to hire me because you filled the position. And that is something that employers have done a lot, even using this process. But then it's very easy for you to be able to say it's clear that it was because of my criminal history information, because that's the only thing that changed.
Or by their actions.
Yeah.
Area looking like he just said, they're not gonna tell you, but they kind of overreact on their suspicious of whatever was going on in their background. By their actions, they had to do drug tests or whatever, and I've seen that.
Yeah.
Over exaggeration.
So has your organization taken on cases like that had happened?
Yeah, we have. Where they've said, oh, sorry, we don't have work anymore for you, right? But because of the timeline, we're able to demonstrate, or we're able to have a really good argument, at least, that it was actually because of the criminal history.
So what happened to that person?
So what ended up happening in the two cases that I'm thinking of is that we reached a settlement on behalf of the person. And so we were able to, secure some monetary compensation. The person didn't want to go back to work there because of how they had been treated by that employer, but we were able to seek a monetary remedy for them. And then the employer had to change their practices going forward, right? And train the folks who did that on these laws.
That's good. Thank you for how you answered the questions that we had. So for this new law in California, does the employer offer a written confirmation of the job offer before they can do
Yeah.
the background check?
Great question. So they don't have to do a written confirmation of the job offer. It's great if you can get one, right? If you can ask for that, but not all employers do that. But if they later come back and say, I didn't provide them with a job offer before running their background check, then they violated the law, right? So either way, they violated the law. If they didn't give you a job offer and they got access to your background check or criminal history information, then they violated one part of the law. If they decided to take the job offer back because of your criminal history information, then they violated another part of the law. So even if you don't have a written job offer, If they ran the background check without giving you a job offer, then that's a violation of the ban the box law.
But back to his question, if he got a job offer
Mhm.
during a phone confirmation,
Mhm.
but he didn't report the phone conversation, and the employer ran the background check
Mhm.
and rejected him, how do you prove that?
So as long as you have proof that they ran the background check, right? Then you have proof that they violated the law. So if they didn't either if we believe
Okay.
him that he got that job offer on the phone,
Okay.
and then they denied him based off of that, didn't do a few set of other things that we're going to talk about in a few slides, and they just said you're done, we don't want you anymore. Then that's a violation of the ban the box law. Or if they didn't give him that job offer, but they did run the background check, then that's a violation of the first part of the law that we've already talked about. Great questions.
Any others?
I had another, I had one not too long ago. I didn't take the job, but I was hired. I guess they already got my information. I just sent out my resume and everything. But that was pretty quick. The first day interview, actually the guy flipped me off
Wow,
right when
I'm so sorry.
he called me in front. I was following instructions. Right when I went up there to come up and give my ID, I was already getting flipped off. I was like, I didn't want this job, but then I did get hired. But after I said I'm not gonna take this job,
Mm-hmm.
not this first day. That's
Yeah.
the first day. I said, forget it.
Yeah, I'm so sorry about that. That happened.
It's bad.
All right, so after the background check happens, an employer can revoke a job offer based on the background check. But there are very specific things that have to happen before they can do it. First, they have to notify you in writing and identify any convictions that are the problem. They have to provide you a copy of the background check, and they have to tell you a date by which you can respond. So they actually have to give you an opportunity to respond to them trying to take away the job offer. So you have 5 days, 5 business days, not 5 normal days. So 2 of the days are of the weekend, you get 2 more, to respond. And you can respond with things like trying to correct errors that you see in the background check. So if they say, we are not hiring you because of this conviction, and it turns out actually you got that conviction expunged, then or dismissed, then they can't use that against you. So you can go through, you can correct that error, and then say, okay, now what's the problem? you can't use this conviction anymore. You can use letters of reference. So getting someone who was at a rehabilitation program that you did, someone who's worked with you before, this is an opportunity for you to basically try to build your character up and say, okay, I know that you're saying that this particular conviction is a problem, but here's why you should see me as rehabilitated, or here's why this shouldn't be a problem. It's a way for you to actually just try to really drive home for them. I'm a person, even though this happened to me, and I want to make sure that you know that, you can hire me and not be worried about this particular conviction. And that goes into explaining what led to the conviction. So if there's a story about, you used to have a drug problem and now you don't, you've gone through rehabilitation and now that's no longer driving your behavior, things like that can be good things to put in to say, again, I have this conviction, but it's not my story anymore, and I want to make sure that you know who I am right now. Doing things like education that you've done, trainings that you've done, volunteering, work experience, all of that kind of information that can just kind of fill out your application for the employer. So even if you provide all those things, they still might revoke the offer, but they have to do so in writing. And so this gets to your earlier question about evidence. At that point, they have to actually write down and say that they're revoking the job offer from you. And at that point, they're really supposed to consider how long ago the conviction happened, and they have to consider whether it's directly related to the job. So if you have a conviction that's totally unrelated to the job duties that you would have, and they say, we're not going to hire you because of this conviction that you have for, I don't know, say like petty theft, but the job doesn't involve working with money or anything that you could possibly steal, that's very unrelated to your job, and so it might be hard for them to support taking away the job offer for that particular conviction. So they're supposed to have a job-related reason for a particular conviction being the reason they take it away. It can't just be random, like, well, any conviction would have been the reason that we said no. They're supposed to have a job-related reason for it.
Also, is there a certificate already to present to them that you've taken this discrimination certificate so they're aware?
Maybe we should give them that, actually.
give
That's
us
not a
that.
bad idea. Like,
Before
I know my rights.
Because mine is a pattern. I keep on running into the same, spider web or something we call it. I keep on running into the same problem.
Yeah, that's
So I guess
We
here
should
I
think
am,
about
I'm
that.
aware of it, don't you?
right.
That's an idea that we should think about. And if you do have sort of circumstances where you're applying for jobs and being denied and it's related to your criminal history too, you can reach out to Legal Aid at Work and we can do, like I said, a one-on-one consultation with you, or we'll at least give you advice and information about what possible next steps are, and we might be able to do more for you, like helping you write a letter to that employer, informing them of what the law requires and how they may have, violated that law, or helping you file a charge with a relevant government agency that enforces the laws that we're talking about. So we'll talk a little bit more about that at the end of the presentation. If you feel like you're in this spider web, there are options.
When did the Fair Chance Act take effect?
2018, January 1, 2018. And there have been other versions of it that have existed for longer than that, that have sort of taken specific pieces of it. And then there are also different localities that have had a Fair Chance Act that has been around for longer too, like San Francisco, for
Okay,
instance.
the date you mentioned, actually, it's good for a friend of mine. He applied for a job. Now, this is different. It's as an Uber or Lyft driver. It's
Yeah.
not the typical employee.
Yeah.
And,
Yeah.
they don't interview you and then say, we're offering you. You just apply and submit proof that your car is good, insured,
Yeah,
and then they either accept or reject you.
yeah,
But here, he was rejected and notified that
Yeah.
certain offenses showed up on his record.
yeah, and there
Could
are
have been a
specific.
violation there?
There may have been, without knowing more details, there are specific rules that apply to Uber and Lyft and to other folks who are transporting other individuals in their cars. And so we'd have to really sort of dig into what the specifics of that person's criminal record is, and then also, dig into those laws more. But we're covering sort of more general laws that apply more across the board. But there are a specific set of laws that apply to Uber and Lyft. I won't comment on why, but.
They should have explained, right, in
Yeah.
writing to.
Yeah.
the reason.
Yeah. And so, am I supposed to ask a question? You want to ask a question?
No, so just down here again is sort of in timeline form, right? So you get the job offer, and then they can run the conviction background check, right? Only convictions. You get one notice number one, before you get revoked. Then you get an opportunity to respond. You provide a response, and hopefully that leads to work. And if not, that leads to our second notice, right? So you're supposed to get 2 notices total if the job is actually going to be taken away from you. A lot of employers aren't giving any notice. They're just giving a phone call, and they're saying, we don't want to hire you anymore. And that's a violation of this fair chance process, right? So that's a violation of the law on its face. And here's a sample notice that the state agency has put out. I think it's pretty hard to read. I'll just identify a few key pieces. So they have to identify the convictions that lead to the decision to revoke offer. And that's really key, because that's another mistake we're seeing employers make. Even when they give you a written notice, they have to tell you, this is why. It's because of this misdemeanor possession of marijuana charge, or it's because of this felony burglary charge, whatever it is, right? They have to tell you specifically, it's this conviction that I have an issue with. And then they have to give you at minimum 5 business days, right? They can give you more if they want, but minimum 5 business days, and tell you you have a right to respond. Here they can include information about what to respond, and then they have to make an individualized assessment of why these convictions or this conviction should disqualify you from the job. That gets that job relatedness that Liz was talking about, right? They have to talk about the nature and seriousness of the conduct that led to the convictions, so what they evaluate your convictions to be, how long ago the conduct occurred, and remember that some employers can consider things that are longer than 7 years, right? But the more remote in time it is, the less it represents anything about who you are now, right? And then also, they have to tell you about what the specific duties and job responsibilities of the position you're applying for now, right? Because those need to be related. Your conviction and the job you're applying for need to be related. Otherwise, they shouldn't be denying you this job.
And so this is something they're also supposed to do anyway, but if they don't, you should ask for a copy of the background check and look for errors. So this is hitting home a point we've already probably bored you to death with, but it's really important to request a copy of the background check from your employer. It's really important to check for errors, and then if there are mistakes, you have to try to correct those particular mistakes. So you're going to provide the correct information to the employer, and then also to the screening company, so whatever the company that they use to provide the background check, and you have to demand then that they change the report so that it accurately reflects your criminal history or your conviction history, because it's only convictions, so it should accurately reflect convictions. So something should not be on there. This is your chance to tell both the employer and the company to make sure that it doesn't happen again.
So can you confirm for us the convictions are only applicable to felony or just this misdemeanor as well?
Yeah, you can have misdemeanor convictions as well, yeah. Yeah, but if you were just charged with something and say the charge was dropped, that shouldn't be showing up on a background check.
So it would be a good idea to go to the county that you been convicted or cited and get your printout, so that way you'll know what shouldn't be on there, correct?
Absolutely, that'd be an excellent thing to do. So we'll talk more at the end of the presentation about sort of proactive pre-steps that you can take to make sure that you're ready if anything comes up. So exactly, getting a report of your criminal history is one thing that you can do to make sure that everything is matching up. But also be aware that those reports that you get from a county might themselves contain mistakes, and so don't assume just because it's on something the county gives you that it's right. Definitely check with like your memory of what happened, if you have any other documentation of what happened, if you need to contact your attorney. But make sure that both reports are correct, because exactly, you want to be prepared and you don't want to have to be scrambling to do this in the 5 days that you have to respond.
And you can also go to the district attorney's office. That's where it's gonna get filed first, right? So that way, like you said, the stuff that you're not, you've been charged with, to make sure that the DA's office, district attorney's office, gets off of their records as well.
Yeah, that's a good point.
Do you know how developed or advanced are the databases of these counties? Like, because some people don't
I
have,
feel like y'all would know.
they don't have a case number, but a conviction or a case showed up. By just giving their names, would the, say, County of San Francisco or San Mateo, would they be able to dig up that person's record?
Depends on the county, honestly.
Depends on the county.
Yeah, it really varies. Some are very sophisticated and have like complex algorithms where they, as long as they have like one piece of information, your social security number is another common way to pull up these records. And they can pull it up. Others are sort of still, someone has to go back into the back room and search by hand. So it's a really wide range.
Safe to assume that if it appears in the background check, then it is in the record somewhere of
The
the
fact that they
county?
found it?
Yeah, yeah. So
Right?
they, so
So
the,
if it appears.
The background check companies are pulling it a lot of times from the county records, but they're also pulling it from other sources as well. And so even if it's not in the county, it might be on your background check report, which is why it's important to go to the county and get your records from them so you can say, or even if maybe they are pulling that information, but they're not pulling the disposition where you got it dismissed, right? And so, or maybe they pulled it and you had recently gotten it dismissed and the county hadn't updated their records yet, but then you went back and got your updated records that says dismissed, and the background check company pulled it and didn't pull that most recent information. They pulled information from 2 months ago that doesn't have the dismissal. And so it's not safe to assume that, because they are pulling it from those records, but then also from other records, and these mistakes are very, very common.
We need this district attorney's office, I think it's building
For this county.
this county.
Yeah, so you would go to the county where your convictions happen. So if that was Contra Costa County, or if that was San Mateo, or wherever it is.
There's nothing in Sacramento? Is there like a headquarters in Sacramento?
There's a Sacramento Superior Court that you can go to, and I'm not sure if you're able to do it online. I don't have any personal experience with them, but they definitely have a. Okay. Well, if you give us a call too, we can research that, because yeah. Okay, so now we want to the next few slides talk about your response, right? So let's say the employer does what they're supposed to do. They give you that notice saying, we wanted to hire you, but we have some concerns. Here are our concerns. Now you have 5 days or more to respond. And here's what you can respond with. So first, these are some examples of different court records, right, or court orders showing that, for instance, your convictions have been dismissed, other dismissals, and you'll see some of the forms all look different, right, because they're from different court systems. They're from Orange County. This one's a more common one. This one's a sort of standard form that a lot of courthouses use. This is a case summary printout. So this is another option. If you can't get access to the actual order itself, you can print out a case summary, and this can be helpful too when things that aren't supposed to be showing up at all are showing up on your background check. You can take your case summary and say, look, that's not showing up on this official court document, even though it's showing up on this background check by this, commercial provider that you got me.
Or I think one of the things on this one too is if it's showing up as a felony when it should have been a misdemeanor, because in California I've got all those wobblies, so you want to make sure that it's showing up as the right one. And so your response. Besides court records, which are obviously great if there is a charge that's been dismissed, you can also provide evidence of rehabilitation. And so this is an opportunity to talk about education that you've completed or that you're currently enrolled in. That can be something that employers like to see. Letters of recommendation from people who know you, teachers, professors, previous employers. Proof of completing a program. So if you went and did a program, completion of that program, a certificate or something like that from the program is something that can be helpful. Letters from your probation or parole officers saying that you went through the process and that they now see you as rehabilitated, or at the very least, they think that you've met the terms that they set for you. Letters from people who knew you in recovery programs, counselors who can talk about your current state of rehabilitation, proof of community service, anything that's showing that you've done various self-improvement activities are helpful in this situation. Evaluations by psychologists or other mental health professionals, if that's something you feel comfortable sharing with an employer. Letters of support from other people who you think just know you and would be able to say that you would be a good employee and you'd be good for the particular role. Or something from yourself, a personal statement talking about what you have done to rehabilitate yourself or to humanize you to the employer and say, I am more than this conviction, but I do want to have an opportunity to explain what happened and why you shouldn't see this as something that disqualifies me for a job. And so a way for you to really personally respond to what the employer says is the reason that they're not hiring you.
So these are just some examples of that. So there's, a sheet about your community service. You got your AA from community college, or you're currently enrolled in classes in college. You got your GED certificate or a high school diploma, a certificate of completion for a drug abuse program, a certificate of completion for an anger management program. And this is just a letter from someone saying, and this person actually decided to disclose their convictions prior to applying, even though they didn't have to, right? Even though the law now says that they don't have to do that. But, they said, I anticipate that you may have some concerns about my criminal history, so I want to explain that to you. I've attached a copy of my official criminal history. I was arrested this year for 2 misdemeanor charges. This is what they were. The charges were nolle processed, which means that the charges were dismissed. I am in the process of having the charge expunged or restricted from my record. I do have 1 misdemeanor conviction. I received 12 months of probation, attended anger management counseling, which I successfully completed. I made a mistake, but I have moved on with my life.
And so here are some more sample letters that you could offer. And so, do you want to read them, or do you want to can you read them? Okay.
Yes.
We'll let you read them.
for the video, right? So one here says, I was
Yeah,
convicted
good
of grand theft and sentenced to 3 years. During my incarceration, I realized how my actions hurt other people and learned how to overcome the urge for instant gratification. I dedicated my time to reflection, self-improvement, and ultimately discovered my passion for learning and technology. After taking all the available classes on computers and engineering, I am grateful to have received extensive training in the field. I worked as a mechanic for 18 months and was proud of being promoted after a year of hard work. I'm excited by this job and the opportunity to work for you, right? Very short, succinct, sort of laying out the facts of what happened and then explaining how that conviction no longer represents who that person is, right, if it ever did.
Do you have samples of these letters on the website?
We don't, but we're working on putting those together, yes.
Like templates, right?
Yeah, and it is sort of very personalized, right? But I think there are often these common things, right? A lot of my clients, for instance, have talked about, you know, how they were young when it is whatever they did, how now there have been life changes, like having children, for instance, or having a partner who really is stabilizing in their life, right? And so there's some themes that I've seen across different clients, but it really has to be specific to you, right? And we can sort of write like introductory sentences for you, and we can help you. If you call my office too, that's something that we might be able to help you with depending on capacity, or we'll be able to send you to some samples as well. So this is just a copy of the final notice, so it kind of mirrors again, right? They have to tell you, here are the convictions, and then they have to take into account your response. So in the final notice, they have to say, we took into account your response of what you gave us. We took into account the letters you submitted, or your personal statement you submitted, or your evidence of completion of these substance abuse programs. And even despite that, we still think that we can revoke your job offer because of these reasons. And the law sort of doesn't exactly say what it is that they need to include in this. It does say that they need to tell you, right, that they're finally revoking your job offer, and it says that they need to have considered, again, the job relatedness, right? The relationship between your convictions and the conduct around them and the job and the time that's passed. They don't necessarily have to include that in the final written notice, unfortunately. This model from the state does include that, but they do have to tell you we're revoking your offer finally. And they also have to tell you that you have the right to file a complaint with the state agency here, which is something we'll talk a little bit more about later.
Pop quiz. So, can your employers ask you about past arrests? If you think yes, raise your hand. If you think no, raise your hand.
Some of us aren't sure.
Arrests.
Only conditions.
Only convictions. So, wait. And if it's open, I forgot about that one too. Yes. If it's currently open, they can also ask you about that. And can they run a background check on you? Yes?
Just after the job offer.
Yes. Exactly.
So, question, how can you phrase your question, just to address any current open arrests? If they can do that.
So,
Good question.
yeah, that's a good question. We're not really in the business of advising employers. We represent workers, right? But I think that you could come up with a question that only asks, do you currently have any open cases, right? Okay, so I also mentioned a little bit earlier that there's different versions of Ban the Box and different entities. So the laws we've all been talking about apply to California, so across the state, and that was the sort of major change that happened in January 1, 2018. But there are also over 150 cities and counties across the country that have a Ban the Box or a fair chance policy. The ones here locally, most of them apply to some combination of city employees, so when you're applying to for a government position itself, so whether that be, for instance, applying to be a MTA driver here, or applying to a school, right, when you're actually applying to work for the government, or to a vendor or a contractor with the government, so someone who has a contract with the government, so these different cities and counties have Ban the Box laws specifically related to that, and some of them go further than what we've talked about. 2 cities and counties in California, 11 states and 17 cities across the country, also have more protective local chance ordinances that apply to employers in their city. So San Francisco is the closest one to us here, right? And for instance, they have an explicit rule that says employers can't consider anything beyond 7 years. So if it shows up on the background check, which we already know it's not supposed to be doing, right, on a commercial background check, even if it shows up, they can't use that information, right? San Francisco also says that any decriminalized conduct, so for instance, the possession of marijuana that for non-commercial use, that's been decriminalized, and so they can't use that information ever in San Francisco. And so if you're applying to jobs in San Francisco specifically, or in any of these places for county employees, city employees, or subcontractors, there might be more specific, more protective laws that apply.
I'm sorry, in San Francisco and Los Angeles, that applies to both felonies and misdemeanors, or just misdemeanors?
For which part? So
Then about, it would apply to.
all of it
any
applies to,
conviction,
yeah,
misdemeanor
yeah.
or felony,
yes,
if it's past 7 years.
yes. 7-year rule applies to both. And in San Francisco, you also can't consider infractions, which is another difference. So for instance, traffic-related things are sometimes infractions. We've had workers who have been disqualified because of those infractions, so they're not even getting to the misdemeanor level.
And so a few notes to kind of close this off with just things that didn't really fit other places. So first of all, blanket bans. So we will not hire anyone with a felony. Those are not acceptable, and so or generally are going to be illegal. Almost always. I don't know about always, but you generally can't say we will never hire someone with a felony or we will never hire someone with a misdemeanor, because of the second point, which is there has to be some kind of a nexus or connection between the job and the conviction. So they can't just randomly say, oh, you've got this conviction for petty theft and we've just decided that we don't want to hire you because of that. There has to be some reason that they think that that conduct or that conviction would get in the way of your ability to do the job, that it's somehow related to the job responsibilities. Something that does come up, so Stacy mentioned that sometimes you might get asked at the interview stage illegally whether you have a conviction. So although the employer is breaking the law at that point, if you respond with a lie and say, no, I don't have any convictions, when you in fact do, they might be able to fire you not because of the conviction, but for the lie. So they can say, no, we don't want to hire you because you were dishonest in the interview, and we don't want to hire people who are dishonest. And so that's part of what makes that situation where they ask you an illegal question even more complicated, because then you might be sort of stuck in this place where they might be able to say you were dishonest. And so, you know, it's not an easy one to navigate, but lying is not a good move, because that gives them a reason to fire you that is not illegal, unfortunately.
That is very helpful, because people come in and say, well, I just lie. I can't give them a good reason, like, why not to lie, but now I can say, well, they may have an honesty policy.
Exactly, yeah, so that's always the danger, that employers have a lot of protection for reasons that they can say no to you, and so this is one of them. Licensing is another issue, and so there are different departments and boards that make licensing decisions, and they'll usually have access to a full criminal record in making those kinds of decisions, and so they're supposed to have a process for deciding which convictions or which past behaviors are related to the job and what's related to rehabilitation, but they're going to have more extensive information probably than an employer, it seems like. So if you're trying to work for the Department of Consumer Affairs, they do have restrictions on the 7-year limit. Law enforcement, bank employees, port workers, barbers, health, law, real estate agents, some childcare workers, all of these are jobs that might have a licensing requirement. And so that's another entry point for that criminal record, if you have to get licensed to do the job that you want to do. It doesn't mean that you can't get licensed, but in some positions there might be specific convictions again that mean you can't get a license for certain kinds of jobs. And then there's also, besides all of this sort of procedural stuff, so the process of actually getting a job, there are also protections for discrimination. So if you get treated differently because of your criminal history, that can be wait, I'm actually confused about this discrimination point. Will you make
Yeah.
it?
So let's say there's a white applicant and a black applicant who both have a misdemeanor petty theft, right? And the white applicant gets hired, but the black applicant doesn't, right? And we can sort of identify that it was because of their race, right, that this person was hired. So you are treated more harshly because of your criminal record than someone of a different protected category, so a different race, color, religion, sex, sexual orientation, national origin, disability, military or veteran status, right? Any of those, and we'll talk a little bit more in detail about that. You're treated differently because of your criminal history than someone else with a similar criminal history. And that can also be a separate claim. And we'll talk a little bit more about two different types of discrimination in a little bit. But yeah.
When you say treated, you mean like, for example, when you've been talked down to or yelled at in a different tone?
Yeah, so it can be something like that.
Embarrassed in front of customers, I've gotten that.
Yeah, so it can be something like that, and we'll talk about sort of what makes treating someone more harshly or sort of harassing them or humiliating them, and what's the legally actionable threshold for that. But it can include things like that, or it can be, not getting hired. It can be getting hired but for a worse position. It can be any sort of thing that you can think of that means being treated differently.
You get hired, it's like the first or second day. It's treatment.
Yeah. So that can be a part of a discrimination claim. Yeah. And so these are just the different types of things that are protected in California. So race and ethnicity, gender, national origin, including things like language, religion, pregnancy, age, disability, which includes both mental and physical disabilities, sexual orientation, gender identity, and military and veteran status.
And so this is where the rubber meets the road on a discrimination claim. So there are different ways that you can prove discrimination. And so the one that I think feels most common is disparate treatment. And so that's proving that your employer is treating you differently because of the protected category, whatever it is from this list. So what you need to prove in that case is a comparison, and you have to be able to prove that it's because of that protected characteristic. So if the employer can offer another reason why they might be treating you differently that isn't related to, say, race or gender, then they might not be held accountable for the discrimination. So you have to really hone in on, how can I tell that this is because of my race or my gender or whatever. Disparate impact is another way that you can prove a discrimination claim. And so this one, you don't have to prove that they meant to discriminate. You don't have to prove that they intended to discriminate. You have to prove that they have a policy or practice that might have a disproportionate impact on a specific protected group. And so an example that comes up in this context is a blanket no felony rule does have a disparate impact on people of color. So Latino people or black people who are applying to jobs there's a higher proportion of convictions because those communities are over-policed, they're over-criminalized, and so a policy like that would have a disparate impact on job applicants from those specific racial groups. And then finally, harassment. Harassment is when an employer allows other employees to harass someone based on their protected characteristic. It's kind of like a word that comes up a lot in our culture is like hostile work environment. And harassment claims are pretty hard to prove. It has to be like really bad. The standard is something like anyone who looked at that situation would be like, oh my God, that's awful. But courts assume that any workplace is not going to be that great. So unfortunately, I know it's really horrible, but unfortunately, I know. But yeah, so it has to rise above. It has to be pretty terrible to be considered harassment, unfortunately, and to be protected by discrimination law. But, in a really terrible situation, this is something that can step in and protect.
Actually, mine actually a little bit stronger. I actually had evidence. Customer actually backed me up and was on my side. Thank God. Because I would have thought it was only me. Sometimes you can fall into something, maybe it's my fault.
Yeah.
But since you brought it up, that kind of made it stronger.
Yeah.
It's not me, it is discrimination.
Yeah, so there are like two different kinds of harassment. There can be like a specific one really horrible incident, and that's when things have to be really awful, or there can be just sort of a pattern or like a long term, like this happens a lot and it keeps happening and it keeps happening, and both of those can be ways to prove harassment in a workplace or discrimination based on harassment.
So for instance, if the supervisor you're working with, every day, every shift you work with them says racial epithets, says slurs about, the national origin group that you're included in, or, for sexual harassment, if they're asking you out every day, or trying to touch you every day, or saying something, right? If it's something that's very frequent, or if it's something that's really bad, that can be actionable, unlawful harassment. And it has to be tied to one of those protected categories that we talked about earlier, whether that's race, national origin, disability, sex, all of those different things. So it can't just be they're really mean to you, it has to be because of that, right? The next thing we're going to talk about is retaliation. And so all of these different laws that we've talked about have a component of retaliation. Retaliation is basically just a fancy word that means punishment for standing up for your rights, right? So you complain that your rights have been violated, and then your employer decides to punish you for that by cutting your hours, by firing you, by calling law enforcement on you, anything, by moving your responsibilities, right, so that you're doing worse jobs, anything that sort of is adverse to you, that makes your job or your life worse, right? And if it's because you complained about things like discrimination, wage theft, unsafe working conditions, or any other type of rights violation, then that's something that would be unlawful.
Pop quiz. All right, John, a Latino man, has worked as a bus driver since 2015. He's never had any issues at work and has even received Employee of the Month. Because he wants to be closer to his elderly mother, he moves to the Bay Area and applies to work at a new company. He fills out the application, which does not include any questions about criminal history. The HR person runs a background check on John using the information from his application. John has a series of drug-related convictions, both misdemeanors and felonies, from over 10 years ago that appear on the background check. When HR sees this, they tell John they will not hire him because they do not work with felons. Did the company violate any laws, and what can John do? So, did they violate any laws? Several. Okay, let's start with one. What's the first one you see?
They did not give him the job offer first, then run the background check.
Right, timing.
Yeah,
What
so
else?
they did not give him a job offer first, right, and then run the background check. They just took it from his application and ran it. They didn't get his permission for it either, right?
Anything else?
The 7-year rule.
Yeah. So it doesn't say whether it was a private background check company, right, or whether it was a government live scan fingerprint one or a commercial. But if it was a commercial, then no information from over 10 years ago should be showing up on that, right?
Any other issues?
The blanket rule?
Yeah, exactly. Yeah, they should not have this policy of never working with felons. That's a blanket ban that is unlawful. Anything else?
No opportunity, he wasn't given an opportunity to respond.
Great. Yeah, so he wasn't given an opportunity to respond, right? They just tell him, we won't be hiring you.
And what can he do?
Well, if they give him notice, which they were supposed to do, he can respond.
Go to your office.
Call Legal Aid at work.
Question, like, what if it's not really a policy of the company that to say we don't hire felons? What if the HR guy, it's just his personality, he just says, we're not hiring him because we don't hire felons. So it's not a policy of the company, it's just his personal reaction to seeing this. So was that illegal for him to say that?
It's a great question. So the law says that either a policy or a practice. So it doesn't, to be a policy or to be unlawful, it doesn't have to be something that's written down somewhere in the employee handbook, right? If this is something that they're repeatedly doing and they're not hiring any felons and you can prove that, right? Then that would be something that would be unlawful. So odds are, if the HR person who's making all the decisions to screen folks, right, about who gets hired and who isn't, is telling you this and is doing this, then that would be unlawful. Yeah.
So question, you mentioned that 11 states and 17 cities have the but what if the law applied for the person who originally lived in California, who had the convictions, and they moved to the other states who may not have the law?
Great question. Yeah, so it matters where you're applying to the job, right? So it doesn't matter where your convictions are from. If you have convictions from Georgia, but you're applying to a job here in San Mateo, all these laws apply. The reverse is also true, unfortunately, right? If you have your convictions in California and you're applying to a job somewhere outside of California that doesn't have these laws, then you're not, these laws don't apply and you're not protected by it. Same thing if you're applying to a job in San Francisco, even if you live in San Mateo, your convictions are down here, then the San Francisco laws that are more protective apply. So it matters where you're applying to the job or where you'll be doing the job. Sometimes we have corporate is located in Los Angeles and I'm applying to the job down there, but I'll be doing the job in San Francisco, right? So where will I actually be carrying out the job responsibilities? So that's what matters.
Question. Are all background check companies required to give the person a copy of the results, right? Is it possible that an employer runs a background check without your knowledge?
Yeah, so it is possible. So for all commercial background check companies, you should have the option at least to get a copy of the background check. And now with the fair chance laws, so that's based on consumer laws. Now with the fair chance laws, you should be able to get a copy if they're going to be denying you because of that. But it's sort of, you don't know what you don't know, right? So if they're running it and not telling you they're running it, then you're in a situation where it's going to be pretty difficult to prove. They're not supposed to be doing that. It's unlawful, but it might be happening.
But there's no provision in the law that actually, protects the.
Well, the only provision is if you find out, right? So if you're able to prove it. So they're not supposed to be doing that. There's steep penalties if they find out. If particularly for the background check companies themselves, right? There's an up to $10,000 penalty that can apply if you violate these consumer laws and do certain things that you're not supposed to be doing as a consumer background check company. And so they're high penalties, but yeah, sometimes they get away with it.
How many on time do we have time?
We're
for
not
the
so
other
good on time yet, so I think
Okay.
we're gonna skip the next one. Will you go back to it for just a second? So we're not gonna go through it, but I just wanna make the point that these laws also apply not just at the beginning, but sometimes we've had clients who've been working for companies for a long time, something changes, a new manager comes in, sometimes the company gets acquired by some other company, and then they run background checks and our clients get fired, and these laws all still apply in that position, and we have a much stronger case, right? Because the person's been doing the job successfully for, in some cases, months, years. We've had clients who've been doing the job successfully for 3 years here in our case, right? So I just want to make that point.
Are we gonna, do you wanna do wage theft just like really quick? Okay. All right, so this comes up a lot as well. Wage theft and equal pay. And so we wanna quickly just cover some of this because I've done the workers' rights clinic for now 2 years, and this comes up in so many of the intakes that I have with clients, so it's important that you just know what your rights are with regard to your wages. And so wage theft is not just they literally don't pay you, but it's also not getting paid minimum wage for all the hours that you work, not receiving overtime, not being reimbursed for your work-related expenses, not getting meal and rest breaks. So there are pretty stringent requirements about getting meal and rest breaks in basically all jobs, and not getting your mandated sick leave or tips. And so this is just to show you what the minimum wage is in California, in Redwood City, and then in Berkeley, San Francisco, and Richmond all have higher minimum wages. And you also are required to have 3 paid sick days a year. And so all of these laws are very important because often employers won't pay the time and a half that you're entitled to at overtime. They won't give you breaks, and all of those things might make you entitled to both getting paid for them and also penalties for the employer's failure to provide them.
And a quick note on the minimum wage too, a lot of these are going up. So in California, for instance, every January 1, it's going up. And so this is something good to just, when you have a moment, when you're bored waiting in line somewhere, Google minimum wage in whatever city you're working, right? California or Redwood City, because every January 1, the different cities have different trigger dates. Some are in the summer, some are in different months. So just to, Google it, because these are constantly going up, or call my office and we can tell you.
Every year it's going up $1?
The California one, yeah, every year is going up until 2023. And so another set of laws that is sort of a specific discrimination law is about equal pay. And so this is a lot easier to prove than your general discrimination laws. When you're being paid less than another employee of another sex, race, or ethnicity who's performing substantially similar work, so it doesn't have to be exactly the same work, but they're doing basically the same job as you are, and you're being paid less than them, then that's you have an equal pay claim. And then the employer must actually prove if that's happening. If you're able to show I'm paid $1 less than my coworker who's doing the same thing, the employer has to then justify that, providing a legitimate reason for that, like things like seniority or education or training or experience. It can't be any more prior salary. So if that person came in and said, I'm negotiating a higher salary because I was being paid more at my last job, it can't be that anymore, and that's a new law in California. Okay.
So this is the what do you do part. So we've given you a lot of rights and not necessarily a lot of things to do. But now, what do you do? So we've talked about a few things. Can anyone remember some of the stuff that you can do if you feel like your rights are being violated? There's some easy ones.
Contact the employment board.
Yep, exactly. Contacting a government agency. So there are multiple ones for different issues that you have, but yeah, exactly. DFVH or who else?
EEO.
DOC, yeah.
DOC,
Yeah.
sorry.
Other ideas for what you can do if you know that your rights are being violated?
Come see you.
Yeah, call Legal Aid at Work. There's a chance. We'll at the very least be able to tell you which government agency to call.
Okay, so here are some options, right? So the minimum that you can do is just document what's going on, right? So whether that means saving texts and emails and letters in a safe place, making sure they're not just on your phone, for instance, because if you lose that phone, what happens? Keeping a journal of what's happening, so even if it's a phone call, on such and such date at such and such time, I had a 20-minute conversation with this person whose role at the company is they're in HR, here's what they told me, here's what I responded, here's what they said back to me. So just documenting that, right? There's very little risk in that, but just keeping records for yourself. You can try to informally resolve it, so you can complain to your boss or to HR. You can try to talk right to the company itself about what's going on, about what they're doing, try to educate them about what laws they might be violating. There's a question mark there about whether or not to do that in writing, right? If you do it in writing, then you have evidence later on, but then it might be less effective. So I think that's a decision, again, that you have to sort of make for yourself. Or maybe there's a way you can do both, right? You can have a call with the HR person and then send a letter or an email afterwards saying, here's what I understood we discussed during this conversation. Please let me know if any of this isn't what you understood from the conversation too. And then prepare, right? So that gets back to what we were talking about earlier. Knowing your rights, so you're already well on your way here with that. Know your own records, right? Which includes getting your own records. And we'll give you a resource on the next few slides to get your rap sheet. So one option you have is to go to the individual courthouses or the different superior court systems where you may have a criminal record, or you can also get a California rap sheet or a nationwide rap sheet if that's more applicable to you. Which again, these have errors, but this is a good sort of first step to be able to have some sort of evidence before that 5-day clock starts ticking, that 5 business day clock that you have to respond, to be able to have those records already to be able to show, no, that conviction has actually been dismissed. You can start gathering support letters now, right? If you know or if you think that this might become an issue, or if it's been an issue in the past, start gathering support letters from people who might be able to write them for you. You can participate in clean slate programs so that your records are dismissed or expunged, and so then that limits sort of how employers can use that information. And you can prepare your own response letter, right? So that articulation of what it was that happened, the nature and circumstances surrounding your criminal record, and explaining how that doesn't represent the type of employee that you would be today. You can also take legal action or consult an attorney, right? And taking legal action can look like going to court and filing a lawsuit, but you can also go to different government agencies that we're going to talk about in a little bit. And the important thing to note about this is there are deadlines to file these complaints, either with the government agency or in court, and they can be as short as 60 days or as long as 300 days or several years. So even if you are still unsure about whether you'd like to pursue something, it's good to sort of get the information about what the limitations on those are. Yeah.
How about for the background check company? What can be done?
Yeah. So you can take legal action against the background check company as well, and you can sort of try to do all of this. You can do the same menu of options, right? You can document what's going on, you can contact them and try to informally resolve it. They often also have internal processes that you can try to use to correct any errors, and you have to sort of submit, here's the evidence of what's wrong with your background check. Here's the evidence that that's actually incorrect. You can take legal action against them, same thing. It's sort of harder to prepare against a specific background check company because there are very many different ones, right? So you don't know what necessarily background check company the employer you're applying to is going to use. But it's the same set of things. If you have your own records, you can use those same things with the background check companies.
If you do, you have a copy of the report, which is clearly
Exactly.
insufficient or didn't have enough detail.
Exactly.
And you already lost the 5-day opportunity to
Yeah.
respond to the employer.
Yeah.
Anyway, your only actions, I mean, of course, correcting the report,
Yeah.
getting the report correct.
Yeah, and even if those 5 days elapse, there may still be something that you can do with the employer. So I've had folks come to me after they get a final revocation and they didn't know what to do when they got those 5 days, that letter that says respond in 5 days, and then we've been able to intervene and get them rehired once we've submitted things. And of course, that took sort of some element of willingness to cooperate on the employer's part, but it has been effective in the past. And then, so the last thing is, so the deadlines to file a complaint are important, right? Because after those certain deadlines elapse, sometimes you're not able to take any legal action against someone. So it's important to call my office or consult with another legal resource to know what the deadlines are, so that you can know whether or not you need to take action now, or whether you have more time to think about whether you'd like to pursue any legal action against them. And then you can also turn to your community. So the reason that we have Ban the Box and Fair Chance now is because a group of folks called All of Us or None, which is a grassroots organization made up of formerly incarcerated persons themselves, organized and said, there's something unjust happening right now with how we're being treated. And then they lobbied the legislators in California and got this law passed. So that's the reason that we have this now, and I think it's a good first step. There's a lot more that we can do, and there's a lot of power in organizing and sticking together to put pressure on folks who are doing the wrong thing, and then folks who are doing unlawful things too. Okay.
So these are just some resources. We mentioned calling Legal Aid at Work is always a great option if you have just general questions. We can give you advice, who to go to, what these statute of limitations are, how long you have to file a complaint if you want to file a complaint. There are also other nonprofits who are doing work around expungements and record clearing, and so those are listed on the left-hand side. They also will do other legal information as well. And then government agencies. So the DFEH, the EEOC, and then the California Labor Commissioner are the three. Those are almost always the people or the government agencies that legal aid will send you to if those are the proper agencies for the complaint that you have. Their websites are also pretty decent in explaining to you what they cover and what they don't cover. So that's also a great place to just start to look on their website or give them a call. Do we have this information on a card?
I was just gonna say that.
Not
Yeah,
for the agency, so we'll leave it up for a little bit
Yeah,
longer.
we'll leave
We
this
have
up.
our information, but not for this and that, and then this as well.
Yeah, so yeah, here, we'll leave it up for another second if people want to write it down. Or we can put it up while we're saying goodbye.
And these are some more resources that are sort of more local here. So San Mateo Law Library has some wonderful self-help materials that if you have a pretty, simple expungement or dismissal case, that you can use those materials to help yourself go through the expungement process. San Jose Record Clearance Project also has a service available where you can go get a copy of your rap sheet for a minimal fee. It used to be $25. I think it might still be that. And so you can go and get an appointment, and they fingerprint you right there, and they give you a copy of your records. Stanford Community Law Clinic does expungements on a limited basis or dismissals. And then 2 resources for looking for jobs. The Nova Job Center is here in the local area, and they have a program related to Fair Chance. And then there's also a list of Fair Chance pledge employers. So employers who have said, we want to hire folks with criminal records because we think it's important to give folks second chances, or in some cases first chances for folks. But so this is another place you can go. And we'll go back to these after the presentation.
I think that's it. That's this, right?
Yeah.
Yeah.
And then this is just again a reminder of our workers' rights clinics, which I'll pass out.
Yeah. So we
And-
have that one,
Yeah.
and then I'll leave these up while we close.
Yeah. Do you want to just go to other rights? and
Oh,
then
do
we
you
can-
have that?
Yeah. So we covered a lot in an hour, but there's a lot more out there. So I just want to quickly let you know that there are disability rights that are related to employment, where you can, and disability is defined not only sort of as what we think of, deafness, blindness, someone in a wheelchair with mobility impairedness, but also hidden disabilities, which oftentimes can be a result of having contact with the criminal justice system. Things like PTSD, mental illnesses, cancer, diabetes, all of these can be qualifying disabilities under the law that then give you access not only to non-discrimination, but also to something called a reasonable accommodation, where your employer has to affirmatively do something to allow you to do the work, right? So that can be things like if you're pregnant, providing you with this, and you're a cashier, providing you with the stool. Or if you have PTSD and you're taking certain medication that makes it hard for you to always arrive on time at 9 o'clock on the dot, maybe it's giving you a 15-minute window where you can be late. And you can work with your doctor and your employer to come up with accommodations that fit to your disability. Disability can also include past drug addiction if you're no longer using that illegal drug. And so I've had clients, for instance, who have been receiving methadone treatment, right? And there's a drug test that they have to pass as part of their employment, but a methadone treatment program can be an exception, a reasonable accommodation to that. There are rights of domestic violence and sexual assault survivors at work to time off, to seek medical help, safety-related accommodations, to go to court. The immigrant workers' rights, so undocumented immigrant workers, all the rights that we've talked about apply to them as well, except for the last thing we're going to talk about, unemployment insurance. There are work and family-related rights for pregnant women, new parents, and caregivers, giving folks rights to take time off from work, paid leave to bond with a new child, or to care for your own illness, or to care for a family member's illness. And then there's also unemployment insurance, which is available not only to workers who have been laid off, which is I think what we mostly think of, folks who've been laid off through no fault of their own, but also to folks who quit with good cause. So for instance, if you were being discriminated against or harassed at work and you quit, that would likely be good cause and you'd be eligible for unemployment insurance. And so that's just a rundown really quickly, but these are all things that my office works on. And so if you have questions related to this too, if you have friends or family members who have questions related to this too, then you can give us a call.
And especially the bottom two, the work and family related rights and unemployment insurance, there are requirements often about like how long you have to have worked at a place to get them and things like that. So you have the rights, but you might not have the rights. Unfortunately, they put a lot of restrictions. And then we'll put this up.
Yeah, and so I'm also going to pass out the Workers' Rights Clinic postcards, which we talked about, and then a postcard specifically for the Racial Economic Justice Program.